Hey everyone, welcome to The Explainer. I'm absolutely thrilled to be your virtual TA today. If you're a law student, maybe a journalist, or honestly just a really focused liner trying to figure out exactly where our right to free speech ends and our right to a good reputation and privacy begins, well, you're in the exact right place. Today, we're going to totally ace our understanding of defamation and privacy torts. We do have a lot of ground to cover, but don't worry, we're going to break the whole thing down step by step using 5 absolutely foundational case briefs. So here is our syllabus for today's session. We'll be looking at 1. Defamation under common law, 2. Public officials and actual malice, 3. Private figures and public concern, 4. The 4 privacy torts, and 5. Offensiveness in privacy cases. All right, Section 1, defamation under common law.
Okay, so before the Supreme Court even stepped into the ring, defamation was strictly a matter of state common law. And historically, it operated as a strict liability tort. Basically, if you published something false that hurt someone's reputation, you were on the hook, period. To bring a successful lawsuit, which we call a prima facie case, a plaintiff has to prove 4 specific elements. First, there has to be a defamatory statement. It literally has to injure a reputation or expose a party to hatred or ridicule. And quick note for your outline here, pure opinions, insults, jokes, hyperbole, those don't qualify. Second, the statement has to be of and concerning the plaintiff. People actually need to know it's about you. Third is publication, which just means it was communicated to at least one third party. And finally, damages.
Now, you're definitely going to see this classic exam distinction, and it's all based on exactly how the defamatory statement was made. So if the defamation is written or visual, it's called libel. Because written words have permanence, right? They stick around. So the law traditionally presumed general damages. You didn't even have to prove you lost a specific dollar amount. But if it's spoken, that is slander. And for slander, plaintiffs traditionally have to plead and prove special damages, which means actual calculatable economic loss just to get in a courtroom door.
Section 2, public officials and actual malice.
So that was our strict liability baseline. But then, the 1960s happened. Let's look at the landmark 1964 case that injected the First Amendment directly into state defamation law, New York Times v. Sullivan. Let's dig into the facts and pose our first Socratic question. In 1960, a civil rights group took out a fundraising ad in the New York Times to support Dr. Martin Luther King Jr. Now, the ad contained a few minor factual errors about police actions down in Montgomery, Alabama. L.B. Sullivan, a city commissioner, sued for libel and won a massive $500,000 judgment in state court. And get this, he wasn't even named in the ad, and he couldn't prove a single dime of actual financial loss. So here's our question. Can a public official win a libel suit over a civil rights ad containing factual errors simply because it hurt his reputation?
Well, the Supreme Court came back with a resounding no. They totally reversed the Alabama court. The justices realized something crucial. If critics of the government have to guarantee the absolute truth of every single fact they state, or else face total financial ruin, they're just going to stop speaking. It would chill speech completely. So the court declared that our profound national commitment to uninhibited, robust, and wide-open debate on public issues desperately needs First Amendment breathing space. Because honestly, sometimes factual errors are just inevitable in free debate.
So to protect that breathing space, the court created a brand new standard for public officials. You're going to want to lock this black-letter law into your notes right now. Actual malice. To win a defamation case, a public official must prove by clear and convincing evidence that the publisher either knew the statement was false or acted with reckless disregard for the truth. What about the New York Times failing to check the ad against their own news files? The court said, hey, that was at most mere negligence, and mere negligence in checking facts is absolutely not enough to prove actual malice.
Section 3, private figures and public concern.
Okay, let's leave the realm of public officials for a minute and look at everyday private plaintiffs with our next study question. We're looking at Gertz v. Welch from 1974. Elmer Gertz was a highly reputable private attorney representing a family in a civil lawsuit against a police officer. Well, a magazine called American Opinion falsely accused Gertz of being a communist fronter and the architect of a police frame-up. The magazine argued, look, police controversies are a matter of public concern, so Gertz should have to prove actual malice, just like Commissioner Sullivan did. But does he?
Actually, the Supreme Court said no. They reasoned that private individuals are way more vulnerable to injury than public officials. And if you think about it, why is that? Well, public officials usually have much better access to the media to rebut false claims, and even more importantly, public officials have voluntarily exposed themselves to the risk of public scrutiny. Elmer Gertz didn't do that at all. He was literally just doing his job as a lawyer. So for private individuals, states are totally free to use a lower standard, like simple negligence, as long as the plaintiff is only recovering for actual proven injuries.
I love this because it beautifully illustrates the entire constitutional framework in one matrix. We've got Sullivan right at the top, Gertz in the middle, and down at the bottom, the 1985 Dun & Bradstreet case. In that one, a 17-year-old high school employee accidentally reported that a construction company had filed for bankruptcy, and that report was sent to just 5 subscribers. The court ruled that a confidential credit report is a matter of purely private concern, and because of that, the old common law strict liability standard still applies.
So trace this legal evolution chronologically. Over 20 years, the Supreme Court meticulously refined how the First Amendment protects speech, balancing it perfectly against both the status of the plaintiff and the subject matter of the speech itself. It is such an incredibly elegant framework once you see it all laid out like this.
Section 4. The 4 privacy torts.
All right, take a deep breath because we are pivoting hard to the second half of our explainer. We are leaving defamation totally behind and entering the realm of the right to be left alone. Tort law divides the invasion of privacy into these 4 distinct claims. And listen, I want you to explicitly keep these mental buckets totally 100% separate from the defamation rules we just learned. For instance, remember how in defamation the absolute best defense is the truth? Well, in privacy law, particularly the public disclosure of private facts, the information is entirely true. The issue is just that it is absolutely none of the public's business.
Section 5. Offensiveness in privacy cases.
So the real sticking point in privacy law is often deciding exactly what crosses the line, like what actually counts as highly offensive to a reasonable person. To figure this out, let's challenge ourselves with the facts of DeTeresa v. ABC. Beverly DeTeresa was a flight attendant on O.J. Simpson's flight to Chicago right after the murders of Nicole Brown Simpson and Ronald Goldman. An ABC producer went out to her condo in California. She declined to go on camera, but she did voluntarily chat with him at her front door about the flight. Unbeknownst to her, the producer was recording the audio and had a cameraman filming her from out on the public street. ABC later broadcasted a 5-second video clip. So, was this a highly offensive intrusion upon her seclusion?
The Ninth Circuit Court of Appeals actually ruled against her, and the rationale here is super fascinating. The court noted that the producer didn't use any sort of deception to get into her house, right? He didn't sneak into a hospital room. He was just standing on her doorstep, which is a place visible to basically anyone walking by. And the cameraman parked on a public street. Because she spoke voluntarily to a known reporter in plain view, she had absolutely no reasonable expectation of privacy. Therefore, as a matter of law, the intrusion was not highly offensive.
Okay, let's look at a totally different type of privacy tort: public disclosure of private facts. Here's our final Socratic question, straight from Miller v. Motorola. Joy Miller told the resident nurse at her employer, Motorola, that she was taking leaves of absence for mastectomy surgeries, and the nurse promised strict confidentiality. But then, the nurse told Miller's coworkers. Now, normally, this tort requires that facts be communicated to the public at large. So does telling just a few colleagues actually count as making something public?
Yes, it absolutely can. And here is your final gold star black letter law for the session, the special relationship exception. The Illinois court recognized that having your deeply personal medical information exposed to a small group of fellow employees or club members or church members, that can truly be just as devastating and highly offensive as a broadcast to the entire world. The context of who is hearing the information matters just as much as how many people hear it.
So think about that special relationship exception for a second, and then think about Teresa standing on her doorstep. We've traced this law all the way from strict liability common law up through the 1990s. But look at this final question. Today, when every single one of us is walking around carrying a high-definition camera and a global broadcasting platform right in our pockets, what even is a private fact anymore? How on earth will these 20th century precedents survive the digital age? It's definitely a provocative thought to leave you with. Thank you guys so much for joining me in this study session. I really hope this explainer brought these concepts to life for you. Keep analyzing, keep questioning, and I will see you next time.